having acted unreasonably in their approach to determination of the application and subsequent actions during the course of the appeal process. The consequence of this is that the appellant has been caused to incur unnecessary and/or wasted expense. The framework requires that local planning authorities should approach decisions on proposed development in a positive and creative way. Further, they should use the full range of planning tools available and work proactively with applicants to secure developments that will improve the economic, social and environmental conditions of the area. Decision makers at every level should seek to approve applications for sustainable development where possible. This is a site allocated for residential development. The application is consistent with the development plan. It was supported by extensive documentation and technical submissions, which resulted in no objection being received from any statutory consultee, and a recommendation for approval from the professional officers of the council. However, the council refused the application for 7 reasons. Several of those implicitly questioned the sustainability of the site for development, and the footnote refers in particular to reason 3 and 7, and appear to be in principle objections to the extent that the reasons assert a lack of information. The council, being positive and creative, ought to have requested further information of the applicant. They should have provided the opportunity for information to be submitted to address any of the residual concerns of members, albeit the officers were satisfied. More particularly, the council's unreasonable behaviour, which the appellant seeks an award of costs against, is as follows. Firstly, the council formally withdrew reasons for refusal 1, 3, 4, 5, 6 and 7 on the 14th of December. And secondly, the council's approach and behaviour in pursuing reason for refusal 2, and there are several facets to this. First, a change set out in the council's evidence to the inquiry to the express terms of reason for refusal 2, which asserted a lack of information in relation to attenuation basins and a claim of inappropriate development in the Greenbelt as a consequence. Secondly, the fundamentally incorrect interpretation of the relevant test in paragraph 150 of the framework, with the council approaching the defence of reason for refusal 2 on the basis that preservation of openness required no negative effect, even to the smallest degree. And thirdly, an incorrect approach to the interpretation of NPPF Greenbelt policy to import the need to give substantial weight to any Greenbelt harm, either in the process of determining compliance with NPPF 150 or as an additional test, even if development is deemed to be appropriate, having applied the terms of NPPF 150. The council's late introduction, so this is another strand of unreasonableness beyond the Greenbelt point. The council's late introduction of arguments as to conflict with several local plan policies that were not in the reasons for refusal in setting out its position in the statement of common ground, which policies were not subsequently pursued by the council in Councillor Foster's proof of evidence or otherwise. And finally, as a heading, the council's unreasonable approach and rejection of the use of planning conditions, which were always able to address the terms of reason for refusal 2 as drafted, which was the absence of information leading to the assumption of inappropriateness. So I provide a little more detail in relation to each of those. And to be clear, ma'am, what I'm saying is that there are 1, 2, 3, 4 topics, but the second one's got 3 bits to it. So on the first topic, the withdrawal of the reasons 1, 3, 4, 5, 6 and 7. Paragraph 047 of the guidance lists a range of behaviours which may be regarded as unreasonable in relation to procedural matters at an appeal. The guidance expressly includes withdrawal of any reason for refusal as a ground for an award of costs. On the 22nd of November last year, the Council's Planning Committee considered a report of the Assistant Director of Planning and follow-on legal advice that had been received. Further to considering these, a motion was agreed that the Council would cease to pursue all of its grounds of objection to the appeal. That position wasn't in fact communicated at that point to the appellant. But subsequently, the Council's Planning Committee, as we know, reconvened on the 13th of December. And despite having determined the withdrawal of all of the reasons, members backtracked and determined to continue to pursue reason 2. The resultant position of the Council was communicated to the appellant on the 14th of December last year. And we say the Council acted unreasonably in refusing the application for the withdrawn reasons of refusal. It recognised this in withdrawing those reasons. They were untenable. By the time of withdrawal, the appellant had already been put to the cost and expense in addressing them, in the preparation for the appeal to be submitted, the appointment or reappointment of professional team on those matters, in drafting the statement of case, which was an extensive document and went with the appeal, and the statement of common ground, and significant work on survey efforts by the professional team to respond to those matters. So the appellants therefore seek an initial partial award of cost to reflect all work done, I should say, expended in time and work expended in relation to the withdrawal of reasons up to the 14th of December. By that stage, the appellant's evidence was in substantial progress, and this relates to both substance and procedure. The substantive matter is that the reasons should never have been put forward in the first place, and the procedural point is the late communication of the inevitable. But in addition to that, although the Council had indicated it no longer wanted to defend those reasons, because the appeal had to continue to address the remaining reasons, and because the nature of the appeal is such that it is to the Secretary of State, in fact to you on the Secretary of State's behalf, as though a new application to be determined, and I referred to this in opening, it's section 79(1) of the Act. So the appellant had no realistic choice but to provide evidence on these matters. Further, the withdrawn topics were progressed during the course of the inquiry by interested parties through written submissions. Presentations were made by several individuals in relation to distinct topics, which included those to which the withdrawn reasons had related. It's clear that the appellant had no choice but to respond. Consequently, there was a continued need to call expert witnesses on these technical matters on topics the Council had set running with the reasons for refusal. Without prejudice to the claim for costs related to all work done on all areas that were withdrawn, therefore the appellant also seeks a partial award of costs to reflect all work done between the withdrawal of reasons and the end of the inquiry in relation to those topics. I then turn to the second head, which I said has got 3 parts to it. So this is in relation to the Council's approach to Greenbelt. The residual reason for refusal, reason 2, relates solely to that part of the proposed development which comprises sustainable drainage basins and which the within the Greenbelt. Reason for refusal 2 states that no details of the nature or scale of works necessary to form them has been submitted. Therefore, and I place emphasis on the word therefore, it is concluded that without information to the contrary, the application would fail to preserve the openness of the Greenbelt and conflict with its purposes. The Council's reason for refusal was based on the premise that the lack of information allowed an assumption that the development would not meet Greenbelt policy and could not be approved. This is unreasonable. The submitted information was sufficient to enable the Council to conclude as to the appropriateness of the proposed development. The information submitted included, and you have a note of it in due course, but it's what that information was. I'm not going to read it all out. They had enough. If they needed anything else, they should have said so, and they did not. However, and this is the point of the costs, the case actually advanced has changed. It's now the case the proposal is claimed to be inappropriate on the basis of the information available at the time, not the lack of information. Councillor Foster's position in cross-examination was that members always had a clear view of what SUDs would be and that the committee had enough information at the time to make a decision. The reason for refusal has in effect been changed by Councillor Foster without any authority from the Council to do so or endorsement from the Planning Committee. That change did not receive endorsement either at the November or December 22 committees, and Councillor Foster has not sought endorsement or approval of his position in light of the new material submitted to the Council on the 3rd of February. There has been an unreasonable and unendorsed change of position, and the appellant has been put to additional cost in trying to address the shifting case. This is a substantive claim of unreasonableness and is for a full award of costs. The second Greenbelt point relates to preserving openness. Whilst it was accepted by the Council at the inquiry that the proposed attenuation basins are engineering operations and have the potential to fall within paragraph 150 of the framework, the Council has misdirected itself as to the proper test of preserving openness. This is apparent in Councillor Foster's evidence at paragraph 8.8, and his approach will have coloured the judgment at each and every stage of the Council's decision-making process. The basis of the Council's case has been that the term preserve openness means not at all negatively affecting it, even to the smallest degree. Paragraph 47 of the guidance makes that behaviour, which is acting contrary to or not following well-established case law, regarded as unreasonable behaviour and giving rise to a possible award of costs. Here, the case law is clear. Openness does not mean freedom from development. Preserving openness means keeping it safe from harm rather than maintaining a state of things. In other words, there is a threshold of change acceptable before harm occurs. That is the only proper and valid interpretation of NPPF 150, which allows in principle a range of things that are bound to affect openness. Despite the law, policy, and its application in other cases, the Council has fundamentally misdirected itself as to the right approach to the interpretation of Greenbelt policy. Councillor Foster confirmed that he had been advised the approach he was asserting was the approach the Council always adopted. The Council's unreasonable approach and failure to consider the confirmed legal position in relation to the test has caused the appellant unnecessary expense in producing evidence which sets out the established case law. Indeed, this is a substantive unreasonableness, and it relates to a full award of costs because it goes to the heart of the sole remaining reason for refusal. The third Greenbelt related point is in relation to paragraph 148 of the NPPF. The Council has unreasonably asserted that the application must be assessed against paragraph 148 of the NPPF. The Council have maintained such an approach despite the appellant evidencing well-established case law to the contrary. The Court of Appeal decision in Lee, I think that's actually two E's rather than LEA, Valley Regional Park Authority. The Council's case seems either to be that the substantial weight is to be given to Greenbelt harm. The Council's case seems either to be that substantial weight is to be given to any Greenbelt harm, either as part of determining the tests of paragraph 150 or as an additional matter, even if the outcome of applying 150 is that the development is not inappropriate. Once development is considered not inappropriate pursuant to the test in paragraph 150 of the framework, there is no requirement to further assess harms to the Greenbelt. This is because the development is deemed appropriate as to its impact on the Greenbelt, nor can the NPPF 148 approach, which is all about weighing very special circumstances, be imported into 150 as an approach. Councillor Foster's evidence incorrectly addresses the relevant tests in relation to Greenbelt. This is perhaps understandable, given he's not a professional witness, but the appellant notes the Council did have the benefit of a planning consultant who attended the full duration of the inquiry, but did not give evidence. The Council's approach led to it misdirecting itself as to the correct interpretation of Greenbelt policy. Mr. Howlett did in due course confirm the Council's acceptance that once development is deemed acceptable in terms of impact on Greenbelt, then the assessment process ends there. But that was not until after Mr. Foster had given evidence and does not take away from the unreasonableness of refusing and continuing to defend that refusal based on an error. I then come to the third main topic outside the Greenbelt topics. During the appeal process and negotiations on the Statement of Common Ground, the Council required several local plan policies to be referenced as reflecting their position and discussed on the basis of being in dispute. These are summarised in the Statement of Common Ground at paragraph 8.2, but they are also littered through the rest of the Statement of Common Ground Council's case in relation to the Statement of Common Ground throughout that document. These policies are not in the reason for refusal. They were never authorised to be added to the reasons for refusal by any committee and were not advanced at all in the Council's evidence. They are policies SS1, SS2, SS9, SP4, and even parts of LC1. The Council has fundamentally failed to advance any case on these policies. The appellant was therefore forced to spend considerable time reviewing these local plan policies and ensuring the appellant's proof of evidence addressed them. The appellant incurred wasted expense through time spent addressing additional policies which were subsequently not referred to by the Council during the inquiry at all. This is a partial award of costs in relation to the time spent on that topic. And lastly, I turn to the question of conditions. Paragraph 49 of the guidance lists a range of behaviours that may give rise to substantive award of costs against a council. It expressly includes refusing planning permission on a planning ground capable of being dealt with by conditions, where it is concluded that suitable conditions would enable the proposed development to go ahead. Aside from the council's ability to ask for further information at the application stage, there was a clear opportunity open to the council to grant planning permission subject to conditions which would require a scheme to be submitted. A condition could clearly dictate the scope and/or requirements of that attenuation scheme, which would need to comply with, and what it could and could not contain. Further, the council's unreasonable behaviour is demonstrated by the time wasted contesting and seeking to negotiate conditions in relation to highways matters. This is notwithstanding the fact that such conditions have been agreed between the appellant and the County Council in its capacity as the Highway Authority. At the very most, the draft conditions that were agreed with the Highway Authority only require a very minor amendment to include implementation clause here and there, which could have been easily agreed without wholesale changes. Overall, considerable wasted time was experienced by the appellant in not just the substantive work, but also the administrative work in seeking to agree conditions to bring forward development. The appellant therefore seeks a partial award of costs for all wasted time spent in that regard. So in summary, overall, the appellant seeks a full award of costs. In the event costs are not awarded in full, the appellant seeks partial award of costs in respect of each of the above grounds as indicated. Each element of this claim is severable and independent of the rest. Thank you, Mum.
Okay, thank you, Mr. Sagar. That's clear. Mr. Howlett, are you ready to respond to that costs application?
Yes, Madam, I am, thank you, and I will take it in the order in which it was made.
Is this just going to be verbally or in writing?
It's purely verbal, Madam. I've had the substantive application for about 20 minutes.
Okay. Are you happy to respond now, or did you need more time?
I don't need more time to respond orally.
Okay.
If I was to respond in writing, I would need significantly more time, by which I mean I wouldn't be responding this afternoon.
Are you happy to respond orally?
So I will respond orally, yes.
Okay. Okay, when you're ready then, Mr. Howlett, thank you.
Yes, I shall start with the first of Mr. Stagar's substantive points, which is the Council formally withdrawing reasons for refusal 1, 3, 4, 5, 6 and 7.
Yeah.
There is in my submission a fundamental contradiction in this ground, and if I may put it this way, perhaps a little politically, but unintentionally politically. The appellant is seeking to have its cake and eat it on this point. If it is accepted as a premise that the council erred in refusing the application on grounds 1, 3, 4, 5, 6, and 7, it cannot have erred again in withdrawing them. Because if the view was taken that they were untenable, then the only proper thing to do was to withdraw them. It is common ground that the withdrawal of those 7 grounds was communicated to the appellant on the 14th of December. In the submission that he has just made, he criticises the council for what he described as the late notification of that decision. I do not understand the basis of that criticism, because the decision was made at a meeting on the 13th and therefore communicated to the appellant within 24 hours. There was no late notification of the decision. Now, that left, on the 14th of December, left the appellant in the position of knowing that reasons for refusal 1, 3, 4, 5, 6, and 7 would not be defended, pursued by the council at any time after the 14th of December. And the council, in my submission, in its evidence, has been scrupulous in maintaining that position, as I said it would be in my opening remarks to the inquiry, and as I suggest it was throughout the inquiry. So the decision to go on producing, frankly, massive expert evidence on all of those matters is a decision which the appellant made for itself. And there is a way that that can be measured, and it is this. The appellant introduced substantial evidence on the question of noise attenuation. Noise attenuation was never an issue raised by the council at any stage in the application process, at any stage in pre-application discussions, in the assessment of the application, or indeed in relation to the appeal. And the proper inference for the appellant's decision to do that, in my submission, must be that it was anticipating third-party representations, in particular from the action group, which calls itself Killamarsh Rage. Now, that is fine. That is a decision which it is perfectly open to a developer to make. But if it chooses to maintain expert evidence to the full on matters which the council has withdrawn, but also, and this is the reason I instanced noise, on a matter about which the council never relied, that is its prerogative. And it may well be that that decision was informed by the attitude of Killamarsh Rage. But how to deal with that is a matter for the appellant. The cost of doing so should not then be visited on the respondent. And I sense in Mr. Sagar's submission that he may have anticipated what I've just said and sought to get around it in this way by referring to the withdrawn grounds of refusal as matters which the council had set running. That is to rewrite history. It is a matter of record that from the publication of the possibility of this site being taken out of the green belt, Killamarsh rage, whether or not that is what it then called itself, strongly resisted it on any ground going, including, for example, the legacy mine working condition of the site and the substrata beneath it. And although it's not relevant to the issues before you, you cannot, madam, have failed to pick up the resentment amongst Killamarsh rage that this site became, that the majority of the application site became an allocated site and was withdrawn from the Greenbelt at all. But it is simply wrong to say that those are matters which the council had set running. They had been running long before this application and certainly long before this appeal. So I accept that I cannot have it both ways. Whilst I make no formal concession, and I certainly do not waive privilege in any advice which I or anyone else may or may not have given. If it was wrong to make the grounds of refusal that were withdrawn 1, 3, 4, 5, 6, 7 in the first place, and that may leave me in difficulties up to the date of notification of withdrawal, it cannot follow that the appellant is then entitled to a full award of costs in relation to those matters as though they hadn't been withdrawn at all. And it is perhaps noteworthy, incidentally, that it was anticipated before they were withdrawn that this would have been an 8-day inquiry, timetable to which it may or may not have kept. And as it is, it has been technically a 4-day, but certainly in terms of sitting time, a 3.5-day inquiry. And it seems to me that the council cannot be criticised as acting unreasonably in bringing about that state of affairs. The council's approach and behaviour in pursuing reason for refusal to Mr. Sagar's second ground. And he subdivides that firstly into what he describes as the change of case. I make 2 points about that. It may, with the benefit of hindsight, not have been the most felicitously worded ground of refusal, but it is clear, albeit perhaps for the wrong reason, that the council was taking the position that this was inappropriate development in the Greenbelt and in conflict with purposes and openness. That is the case which the appellant had to meet, knew it had to meet, and has met. And it cannot be said that in substance that there has been a change of position, putting the appellant to additional expense in addressing what Mr. Sagar describes in his written submission as a shifting case. The appellant came to this inquiry ready to meet the argument that this was inappropriate development on the grounds of prejudice to openness and incompatibility with Greenbelt purposes. It's not had to do any extra work as a result of that. So even if there was a substantive change of case, which I do not concede, no costs have been wasted which are attributable to it. We are then criticised really on perhaps 2 grounds which I can take together, and they are the approach to the test of preserving the openness of the Greenbelt and the council's approach to paragraph 148 of the NPPF. And that really amounts to saying, well, the council got the law wrong. I think, Madam, it was you who, in the course of the inquiry, described. In fact, it was the end of Councillor Foster giving his evidence. You described Greenbelt law and practice as not for the faint-hearted, and it may be that after the last 3.5 days, most of those present would tend to agree with that remark. Getting something wrong is not necessarily unreasonableness. Getting something wrong in a notoriously complicated, subjective, discretionary, and I add emotional field of planning, such as the Greenbelt, is not unreasonable. An instance of that, or an illustration of the difficulties that Greenbelt concepts present to anyone who has to deal with them, is that the concept of openness dates back, I believe I'm right in saying, at least to the 1947 Act, but it was certainly present in guidance under the 1971 Act. And it was only after Sam Smith, before the House of Lords, that we actually had a definitive understanding of what it meant. And even now, that decision itself gives rise to difficulty of interpretation, particularly in relation to the twin-headed hydra of spatial and visual elements of openness. With the benefit of hindsight and the proper scrutiny of the application, its impact, and through the appeal process, it may be, though of course I do not concede it, that we fell on Greenbelt. So be it. We took a point and we failed on that hypothesis. But that, in my submission, is not unreasonable. These are matters of subjective planning judgment, and as I shall be submitting later, but I can do it now for the purposes of this application, this is a matter of planning judgment. The council has put forward a planning judgment which was properly arguable. If it fails, so be it, but it wasn't unreasonable. I move then to the next substantive head, and I'm now moving away from the approach to Greenbelt policy. And that is the council's alleged late introduction of arguments as to conflict with several local plan policies that were not in the reasons for refusal in setting out its position in the statement of common ground, which policies were not subsequently pursued. Well, I can't dispute that the statement of common ground says what it says. And the submission made by Mr. Sagar is that during the appeal process and negotiations on the statement of common ground, the council required several local plan policies to be referenced as reflecting their position and discussed on the basis of being in dispute. They are identified. The council has fundamentally failed to advance any case on these policies. Well, I accept certainly the inquiry that I didn't on its behalf. And then this very broad allegation or assertion, the appellant was therefore forced to spend considerable time reviewing these local plan policies and ensuring the appellant's proof of evidence addressed them. The appellant therefore incurred wasted expense through time spent addressing additional policies, which were subsequently not referred to by the council during the inquiry. This is a claim for a partial award of costs. New matters of argument were introduced and not prosecuted. Well, as to the suggestion that the appellant was therefore forced to spend considerable time reviewing these local plan policies and ensuring the appellant's proof of evidence addressed them, my response to that is really a rhetorical really. Again, it's a prerogative for a developer but the applicant from the application stage onwards has addressed every plan policy going to the letter. I don't concede that any identifiable wasted costs have been incurred through the reference to these policies in the statement of common ground. And if Mr. Sagar can identify any specific activity or work that was undertaken as a result, I invite him to identify it. I hasten to add, I'm not falling into the trap of asking you to assess the bill. But of course, it's an important element in any cost application that the appellant must identify firstly unreasonable behaviour and secondly wasted expenditure. And a generalised allegation of the kind made in paragraph 37 of the written application in my submission is not enough. I ask rhetorically, well, what did you do that you would not otherwise have done? Next, and I think, yes, last head, the council's unreasonable approach to not dealing with matters through planning conditions. I must confess, I had thought when reading Mr. Sagar's note that he very courteously, if I may say so, presented on the first day of the inquiry so that we had some idea of what was coming. I had thought that this might be addressed to the process of agreeing the conditions themselves, and in part it is, and I'll come to that. But it appears also to be saying, in fact, well, the council should have granted planning permission subject conditions which would require a scheme to be submitted. That in my submission is an unsound basis to put this application, because of course at the time the scheme was submitted, at the time the decision was made, the indicative scheme before the council was one which anticipated that the attenuation basin area would be available for public access. And indeed, one of the drawings identifies, as you look at it, the right hand, that is the easternmost attenuation basin, as a potential kickabout area. So the council had no reason to think that by the time the application reached the stage which it has, it would be an area free of activity with no public access for anything. And indeed, Mr. Rollinson said in terms, I won't say that it was his decision, because of course it was his client's decision, but it was only when he came in at a relatively late stage that he advised, and presumably his advice was accepted, that on Greenbelt openness grounds activity should be taken out of the equation. So to say, again, with the benefit of hindsight, well, you could have done all this by condition, requiring us to prepare a scheme, which scheme, incidentally, would also have had expressly to deal with the question of pumping stations, railings, so forth, in the terms of the condition now put forward. It is simply not adequate. Particularly at the outline stage, it is not in my submission for the authority to seek to condition an application which prima facie appears not to be consistent with Greenbelt policy and therefore unacceptable, to make it acceptable in a vacuum. So again, even if that is something which the council might have done or could have done, that's a very long way from saying that it was actually unreasonable not to in the circumstances. And there's no real unreasonable behaviour here. And then finally, I deal with the limb of the conditions aspect of this application, which does relate to the handling of the black letter of the conditions themselves. And what is said here is, well, we went off to the county council and agreed conditions with the county council. And that was that, really. You should have accepted them. Well, that's an unfortunate part of the history. The county council, of course, is not the planning authority. And it is for the planning authority to grant or refuse permission, to accept or reject various drawings and so forth, and to decide ultimately what conditions are to be imposed. It is a matter for regret, I suggest. It might even be categorised as unreasonable that the appellant did not liaise as to highway conditions with the county council and the planning authority at the same time. But they didn't. They chose to go to the county council and, as it were, lock in or attempt to lock in conditions based on Derbyshire County Council's suite of standard conditions, and then say to the planning authority, well, here you are, you must agree these. I note that it is not suggested, and I would submit is properly not suggested, that the planning authority, the district council, was wrong to have concerns about the clarity, enforceability and implementation of the highways conditions. And indeed, the session yesterday, I think we were all very tired and a bit punch drunk. It was clear throughout that there was nothing between us as to what these conditions, highway conditions, are intended to achieve. And as I understand it, Madam, you decided ultimately you could, as it were, arbitrate in relation to the drafting. This is a non-point. And again, as to wasted costs, the written application says considerable wasted time was experienced by the appellant in not just the substantive work, but also the administrative work in seeking to agree conditions to bring forward the development. Well, so far as I can see, Madam, the substantive work done in relation to highways conditions involved crossing out Ms. Ray's proposed amendments and saying we stand by what the county council advised us. Which incidentally they didn't yesterday, because yesterday in the course of the hearing it was accepted, in particular as to implementation, that those conditions will require some amendment. Yet it is said, well, here we were acting unreasonably in saying exactly the same thing and offering some differently worded conditions to achieve the same outcome. Well, again, though I don't concede it, it is possible that this matter could have been handled better on both sides. These things happen. But the threshold of unreasonable conduct doesn't come close to being reached in relation to this matter. And therefore, Madam, for the reasons which I have given, I invite you to refuse the cost application as a full application and, having done so, to reject the partial applications within it as well. And as I can assist further, that's how I put it.
Thank you, Mr. Howlett. That covers all the points, so thank you for that. Mr. Sagar, did you want to respond?
Ma'am, I will, but I'll keep it brief. In relation to the withdrawal of the reasons for refusal, I cannot help but come to the very clear conclusion from what Mr. Howlett has said to you, that he effectively accepts that those reasons for refusal were untenable from the moment that they were imposed, and that at the very least, up to the 14th of December, costs are due. That's the only proper construction of what he's just said to you. He relied upon timing to say it was not late if it was the next day. He implied very clearly that the error was in the refusal, not the timing of communication. That was the basis upon which he put the point, and I think it's the basis of the way you take that. In terms of the costs for those reasons subsequent to the 14th of December, He has relied upon the appellant addressing, he says noise, I assume he means air quality, because that was a matter that noise wasn't addressed at all. It wasn't even an issue raised by any of the local residents. But just assuming that he means air quality for that.
I'm sorry if I can interject. That must have been a moment of complete aberration. Of course, I meant air quality.
That's what I'd assumed, Mr. Howlett, and that's not my point.
No, I'm sure it's not, but I just thought I'd better say that, having identified the wrong.
Yeah, don't worry. That's not my point. My point is a choice to deal with things that other third parties raised is entirely different from having to chase down and spend quite a lot of time and effort on things that were actually originally put as reasons for refusal. Not just because local third parties were raising them, but because of the heightened and additional sensitivity of those points, because they had been reasons for refusal, because they were points that the council had raised and put much higher up the agenda of important issues, in their opinion, even though they'd changed their mind on the matter. It's a different category. And the reason we gave evidence on that was because you, ma'am, have to deal with this application as though made to you afresh. And we knew that those points which the council had thought were potential reasons for refusal, refused it on, and then latterly withdrawn, even though Councillor Foster would dearly have loved to have had all reintroduced, were matters that we had no choice. We had a choice in relation to air or ecology, and I am not seeking costs in relation to those matters, only the withdrawn reasons for refusal. So then I turn to the greenbelt points. I think there's an effective concession here that this actual reason for refusal was not the best wording. I think the truth behind that is the case run was a different case to the wording of the reason for refusal. I think when you look at the chronology of what happened, there's actually quite a lot of analysis that's gone in. It's set out in Mr. Rollinson's proof of the material that was before the council at the time and other cases that looked at the level of material that was acceptable to other decision makers at the time, including Poole and Huntingdon, and the analysis of that. For Mr. Howlett to say, well, it might not have been that much work, what he's actually doing is trying to look at the question of the quantum of costs as opposed to the principle. And with respect to him, you determine the principle, others determine the quantum. His response in relation to the approach to Greenbelt, where he has lumped together 2 points, if I can call it the openness point and the paragraph 148 point, is effectively to say, mea culpa, we got it wrong, but that's not unreasonable. Now, I'm afraid that just doesn't wash. That's not an excuse. The council is advised by lawyers. It is advised by professional planners. It has the ability to seek advice on matters to determine the right way forward. It had a professional planning consultant throughout the entirety of the inquiry present. That person is the person who had worked on the statement of common ground and conditions, and in relation to, as I understand it, the statement of case that had been put by the council. And the Sam Smith's case, which Mr. Howlett now accepts, provides a clear view on the question of openness to what it means, not the application of it, and that's not what we're talking about, is a case that is already now several years old. This isn't excusable by saying we chose to defend this case with a non-expert witness who didn't know anything about the law. The council has to make a choice about how it deals with its case. and it is properly advised and should have taken the right approach. By taking the wrong approach, this colours the entirety of the outcome. It colours the entirety of the outcome of Mr. Foster's view, and it colours the entirety of the outcome of the council's decision-making process throughout. If you ask the wrong question, you will get the wrong answer. Late introduction of matters in the statement of common ground. That is set out in some detail at pages 62 to page 68 of Mr. Rollinson's proof, where he sets out his views in relation to those policy conflicts that the council had suggested it was arguing in the statement of common ground, but then didn't. And those paragraphs don't just write themselves, they depend upon analysis and understanding of policy. And it isn't sufficient to say that might not have taken that much time. Again, it's confusing the quantum of the costs with the principle. Finally, in relation to conditions, I'm afraid what Mr. Howlett has said just sort of amplifies the point, really. One of his lines of defence was that at the time of the committee, there was a suggestion of public access into the SUDS area. So if the council thought that made the difference, then it was quite possible to condition the scheme so as to make that not an invited or designed in aspect, remove the kickabout area. It didn't do that. It highlights the whole point. And of course, we know from other decisions, Poole, Huntington, for example, that other decision makers, including the Secretary of State, have found it quite appropriate to impose conditions to deal with SUDS in Greenbelt in order to make them acceptable. What the council has done is effectively closed its mind to the possibility of finding a solution, and that is unreasonable. On the highways conditions, I'm afraid we have to look at the facts here, and I think if Mr. Rollinson was speaking, he would probably say something along the lines of this. Rather than engaging in adding a few words here and there into things that were in the agreed with the county conditions, what the council did is rewrote the whole thing and said, no, we're not engaging in any more conversation over this. My way or the highway, closed its mind to any more discussion. And unfortunately, you saw how that played out yesterday. I don't need to say any more on that. Thank you.
Okay, thank you, Mr. Sagar. I've made detailed notes of both of your verbal cost responses there. Right. Mr. Howlett, are you ready to present your closing?
Yes, thank you, Madam. May I ask, have you received it?
I have, yes, thank you very much.
Thank you. And I take it Mr. Sagar has as well.
So yes.
Yes, I have. Sorry,
Thank you.
I was muted, just giving the thumbs up sign.
Ah, thank you. Madam, I think I can take this fairly briefly, and I'm conscious that you have my speaking note. At the start of this inquiry, you identified the main issues as being whether the proposal comprises inappropriate development in the green belt. Does it preserve the openness of the green belt? Does it conflict with the purposes of including land within the green belt? And is any potential harm to the green belt by reason of inappropriateness and any other harm resulting from the proposal clearly outweighed by other considerations such that very special circumstances exist? I start with the question of appropriate development in principle. the list of forms of not inappropriate development in the green belt at paragraph 150 of the framework is a closed list. Only 2 forms of development from that list are in play. Those are engineering operations and material changes in the use of land. It is common ground that the proposal constitutes engineering operations. As to material change of use of greenbelt land, my submission is this. Mr. Rollinson, in cross-examination on this point, was reduced to saying that the existing use of this site, the greenbelt part of the allocation site, is grassland that sometimes gets wet, and that after the development is implemented, if it is, it will be grassland that sometimes gets wet, therefore no change of use. That, in my submission, is a remarkably artificial approach to the question of use, and is simply not reflective of the true position. Grassland that sometimes gets wet, in my submission, is simply not a use at all. It is the nature of the land itself. And one would no more speak of using land as grassland that sometimes gets wet than one would speak of using land as a marsh or as a rock outcrop, if you happen to be speaking about a marsh or a rock outcrop. And I put the matter in this way. Suppose that the development does go ahead in accordance with the application, the attenuation basins are created, and someone who has not been to Killamarsh before visits this area, looks at the assumed new housing estate, then looks south and says, oh, what's that piece of land used for? The answer I suggest, the true answer would be, well, they're attenuation basins for a sustainable drainage system, or putting it shortly, flood attenuation. That is a use, and it is not the use to which the green belt part of the application site is being put at the moment. So in my submission, it is unarguable but that there is a change of use implicit in this proposal. Assuming that to be right, is it a material change of use? In my submission, it would be. The land could not fulfill the new use without its landform being altered and without it becoming not basins in isolation, but part of an widely engineered flood attenuation scheme, starting in the developed area to the north of the Greenbelt site, and indeed extending so far as the channel down to the brook is concerned, to the south as well. It is a passive use. It's not like being a playing field or a park and ride site or whatever, but passive as it is nonetheless a use. Maintenance visits to which passing reference was made in evidence are incidental to that use. They are not the main aspect of the use. But the change in my submission from grazing grassland to being part of a flood attenuation scheme, and in particular to having the attenuation basins, is a material change. So I both submit and, in one sense, concede that potentially the proposal represents not inappropriate development as engineering works and as material change of use. Whether it is actually not inappropriate depends, of course, on the issues of openness and of greenbelt purposes. And before I turn to those, I mention briefly, please, the other appeal decisions to which reference was made in the course of the inquiry, and particularly in relation to York and the York decision at paragraph 133. It is no part of the respondent's case that attenuation basins are always or are necessarily inappropriate development in the green belt. That could not be our case because, in particular, York and that paragraph say that in the circumstances of that case, the basins, and I think in York there was also a pond in the wet-dry distinction that we heard yesterday, were not inappropriate development in the green belt. There is a logical fallacy in the appellant's reliance on those authorities, as though they demonstrate a proposition that attenuation basins are always and necessarily appropriate development in the green belt. These cases are, of course, all site-specific, and you have to look at, as you know, at each site on its own merits in relation to the proposal which is being put forward for the site in question. And a use or purpose which has been found to be appropriate development on flat greenbelt land near York may not be appropriate on a hilly site south of Killamarsh. And in my submission, it isn't for these reasons. I deal firstly with openness. We rely on the evidence of Councillor Foster. His evidence, and I summarise it briefly because you heard it, is that the combination of the earth moving with the raising and lowering of the existing ground level to create the bunds and the basins, together, he says, with the introduction of water. Mr. Rollinson wouldn't have that. You may have to make a decision about that. But those elements, Mr. Foster said, would cause spatial change of a kind which would compromise the openness of the greenbelt part of this sloping contained site. That is a matter of planning judgment. That is the judgment to which the planning authority came, and in my submission, it is the correct planning judgment. There's, in a quick reference back to the cost application, it is certainly a planning judgment which was properly open to the council to make, whether or not ultimately you agree with it. In cross-examination, Mr. Rollinson would not accept that the proposal would bring about an obviously engineered landscape. And you will no doubt recall, Madam, that yesterday he and I in effect agreed to differ and that I cut short my questions to him about the various, I shall call them photo montages, that's not strictly what they were, but you know what I'm referring to, on the basis that we simply disagreed as to whether this was an obviously engineered man-made landscape. He says not so, but in my submission, however well done, the creation of man-made basins with contoured edges will appear inevitably to be an engineered landscape on this site. Mr. Foster said that he thought that the degree of harm was considerable. When asked by you what he meant by that, he said that it was in the middle of the range of harm. And you may recall that he said, Madam, I submit appropriately and obviously rightly, that the degree of harm here would be less than that would be created by, say, a row of houses, but nevertheless, in his judgment, considerable. I suggest that his layperson's word considerable equates to moderate in planning terms, somewhere in the middle, as he said, in answer to your question. So I invite you to accept that planning judgment. This proposal, if implemented, would compromise the openness of this greenbelt site and the greenbelt land to the south of it. As to purposes, again, only 2 in play, checking the unrestricted sprawl of large built-up areas and assisting in safeguarding the countryside from encroachment. Councillor Foster's evidence was that the attenuation basins represent urban sprawl. And again, there is a clear locking of horns between him, through me, and Mr. Rollinson as to that. But my submission is this: although, as Mr. Rollinson said in answer to a question in re-examination, one can and sometimes has such schemes in a rural context, they are mostly and certainly inherently urban developments. And here it forms part, would form part of an urban development. They would not be required here, but for urban development, they are intrinsically urban in nature. And insofar as they creep across the Great Belt boundary, what they are creeping into is countryside, and as such, they are both encroaching into the countryside and failing to check sprawl. So there's really a double-headed aspect to that, and for the same reason, they both fail to check sprawl and encroach into the countryside. It follows from that, if you are with me, madam, that this is inappropriate development in the green belt, failing to check unrestricted sprawl, the built-up area of Killamarsh, failing to assist in safeguarding the countryside from encroachment. That being so, paragraphs 147 and 148 of the framework are engaged, and when considering any planning application, the authority should ensure that substantial weight is given to any harm to the green belt. Very special circumstances will not exist unless the potential harm to the green belt by reason of inappropriateness and any other harm resulting from the proposal is clearly outweighed by other considerations. I should perhaps mention the question of other harms, which was raised briefly yesterday. We don't suggest that there are other harms. So the application of paragraph 48 in this case turns purely on consideration of the potential harm done to the green belt alone. I move briefly from the framework to the North East Derbyshire local plan. There was some debate about whether the list in paragraph 3 of policy SS10 is a closed list or not. Actually, it doesn't matter whether or not it is a closed list. The policy is engaged in relation to greenbelt harm for the same reason as paragraphs 147 and 148 of the framework are engaged. And again, at the local policy level, this is a proposal which should not be approved, except in very special circumstances. And this appellant does not even allege that there are very special circumstances. And Mr. Rollinson was very clear about that when I put it to him, saying in terms of special circumstances, that is not my case. Now, if that is so, if you are with me on harm to the greenbelt, then the matter stops there because there are no very special circumstances. But it may be that a different view could be taken and that an attempt could be made to point to the benefits which would flow from the implementation of the proposal on the site as a whole, and in particular on the allocation site. And those benefits I summarise as housing, affordable housing, and the economic benefits of construction phase employment and the wider economic benefits flowing from the fact that people move on to the new development. Having money, they spend some of it in the area. I don't actually abandon or shrink from the point that those benefits would inevitably flow from the development of the allocation site, even if the Greenbelt site was not used as part of the flood attenuation scheme, of the sub-scheme. But in any event, those benefits in my submission cannot amount to very special circumstances, and the appellant was right not to suggest that they might. So in those circumstances, the proposal in my submission is contrary to policy SS10 of the up-to-date local plan, closed list or not, and it's contrary to the guidance in paragraphs 148 and 149 of the NPPF. There are no special circumstances. The appeal should be dismissed. Unless I can assist further, those are my closing remarks.
Thank you, Mr. Howlett. Mr. Sager, are you ready to make your closing submissions?
Thank you, ma'am. I am. I trust you have a copy by email, but I'm not certain if you do.
Not yet, I haven't, no. It may be on its way.
Let me just check where we're up to.
If I may interject, neither have I. And I suspect if the council had it, it would have been forwarded to me.
I think it's just being sent now to all parties.
Let me just...
It might take a minute to get across to each of you.
Yeah, looks like my case officer is mysteriously offline all of a sudden, so oh no, they're out of office too. Let me see if I can just find someone. Oh, he's out of office too. This is Easter for you. Where can I go to? Slightly suspicious Alison's not around all of a sudden, but she hasn't gone out of office on. She might be having some trouble. Just see if there's anyone else.
Shall we send it to Helen Skinner? Will that be of any assistance, do you think?
She's out of office too. I'm ahead of you. Let me try somebody else.
So we have details for Mark Bolton, Leanne Palmer.
Yeah, Mark Bolton's out of office as well. Yeah, Leanne Palmer is an option. Let's see if she's in. Oops. Oh, Leanne is typing. So, yes, okay, brilliant. I think she can have a look at Alison Dyson's inbox. So that's useful.
Okay, so we can send it direct to Leanne if you like. We've got her.
Yeah, I think she's actually seeing if she can get hold of it without having to do that.
Okay.
She's pretty good, Leanne. Not that Alison isn't. Alison's brilliant too. I have a bit of a soft spot for Leanne. Just sent it over. There we go. That's how good Leanne is. Not even her area. Brilliant. Yeah, I've got it. And do you have it though, Mr. Howlett? That's the next thing. Shall I get her to send it to you? I think you're on mute.
No, I've very kindly been sent it directly by Mr.
Oh,
Sagos.
perfect. Okay,
Thank you.
we're good to go then. Well done, Leanne. Okay, when you're ready then, Mr. Sagar.
Thank you very much. So, Ma'am, these submissions don't repeat the opening statement from the appellant. I rely on all of that opening, sets out the detail of the site, the application, the proposals, the matters that remain in dispute between the appellant and the council, in terms of the officer's report, which clearly recommended approval. So I turn to the main issues, and I think it's fairly clear what they are by this stage through the inquiry. Whether the part of the development that is proposed within the Greenbelt would be an appropriate development, having regard to the framework and local plan policy, the effect of that development on the openness of the Greenbelt and its purposes, whether any harm by reason of inappropriateness and any other harm would be clearly outweighed by other considerations so as to amount to very special circumstances and the overall planning balance. And there are a number of issues raised by third parties, interested parties. These matters have been thoroughly addressed and responded to by the appellant, both in writing and through calling expert evidence from several expert witnesses. These matters are returned to in more detail later. The appellant has also addressed each of the 6 reasons for refusal the council withdrew on the 14th of December, as the appeal had to proceed as a result of the refusal and notwithstanding the council's withdrawal of 6 of its 7 reasons. The appellant had no real choice but to deal with those matters. The appeal is, of course, a matter to be determined by you as though an application had been made to you in the first place. So I turn to the main issue, the Greenbelt case, and I set out the appellant's position. Reason for refusal 2 relates to the very small part of the site in the Greenbelt. It relates to the claimed absence of information and the details of the proposals in that area. It proceeds on the basis that without further information, the proposal should be assumed to be contrary to Greenbelt policy. It is an agreed matter that the law requires reasons for refusal to be clear, precise and full. The appellant's case has been very clearly set out in the evidence of Mr. Rollinson. The amount of information provided was ample and proportionate to the planning application being an outline. That was accepted both by the policy officer and the case officer at the time, as is clearly set out in those in the paperwork associated with those parties. The information available was in line with other appeal decisions. And then, without prejudice, additional illustrative material was submitted on the 3rd of February, and that demonstrably shows how the proposals meet national Greenbelt policy and local policy. Mr. Rollinson's written evidence addresses reasons for refusal 2 and concludes that the council have taken an inappropriate approach to considering the attenuation basins in the Greenbelt. His written evidence can be found on this topic in his proof, pages 25 to 49. Mr. Rollinson, in his evidence in chief, explained a number of key fundamentals. Firstly, the drainage strategy that underlies the reason the Suds basins extend partly into the Greenbelt, approximately by 20 metres, about half of their width. And this is due to the topography of the site, with an existing valley formed in the southern edge of the site and the remediated colliery spoil mound beyond. The strong policy encouragement for Suds, the location of the existing ponding in this area, with both water from the site itself and the colliery spoil mound, and the need to address existing flooding issues caused by water collecting in this area and flowing down the former colliery access road to Green Lane. There are clear and cogent drainage and topographical reasons for the basins to be located where they are proposed. The effect of the scheme is a betterment of some 60% in drainage and flood risk terms compared to the existing situation. He also explained that the proposed basins are clearly engineering operations. This matter is now accepted by the council. Consequently, NPPF 150 is fully engaged, such that the basins are appropriate development, provided they preserve openness and do not conflict with Greenbelt purposes. Even if it was concluded that the proposals amounted to a material change of use, and Mr. Rollinson says they're not, given the existing and proposed nature of use, they would in any event be covered by NPPF 150 on any proper reading of local plan policy SS 10.3 as well. That is an open list of acceptable exceptions which allows that policy to be easily read as consistent with NPPF paragraph 150. Mr. Rollinson also explained that the correct approach to the application and consideration of NPPF 150 is such that once development is judged appropriate, there is no second test of applying substantial weight to any harm to the Greenbelt, and to do so would be wrong in law. This now appears, despite Councillor Foster's confusion on the matter, to be an agreed approach as explained by Mr. Howlett in his cross-examination of Mr. Rollinson. Mr. Rollinson further explained that the correct approach to judging if openness is preserved is to accept that policy in NPPF 150 has defined certain things as appropriate in the Greenbelt. These will cause change to openness. That change is acceptable up to a threshold, beyond which there could be judged to be a lack of preservation. This is not only the obvious consequence of considering each of the matters set out in NPPF 150, some of which will inevitably have very significant effects on openness, but it is also the approach in case law and is the approach endorsed in all other cases before the inquiry. Openness does not imply freedom from development. If it did, paragraph 150 would be meaningless. In this case, applying the correct approach and the correct understanding of policy, Mr. Rollinson has assessed the appeal scheme by reference to his Appendix 3 ID 4, Appendix 7 and Appendix 8, and these collectively show, first, the small area of greenbelt affected, see Appendix 7, a matter relevant in the context of the Euro garages case, which makes it clear it is the effect on the greenbelt, not just the site as such, that needs to be taken into account. Secondly, the fact that there is not proposed to be anything other than ground remodelling in the greenbelt, and that this can be controlled by condition. Thirdly, the low gradients with a maximum of 1 in 4 and only in one instance created by the ground modelling works. When ID 4, that was the annotated long section, is properly understood. The fact that ground raising will be below and tie into the surrounding land that is in the greenbelt and will use the natural topography to create naturalistic undulations is also seen in the cross sections of his Appendix 3. He refers to the occasional water storage in this area, which is a naturally occurring feature and doesn't itself affect openness. Indeed, as proposed, it would be only some 3 or so times a year that there would be any water in it to speak of at all. He explains that it's difficult to contemplate SUDS engineering operations that could have any lesser spatial effect on openness, given the scheme and its locally surrounding topography. He also explains that the very localised areas from which the SUDS basin could be seen, particularly when the allocated housing site is developed, results in a very limited visual effect shown clearly in the montages in his Appendix 8. These montages, as explained in detail by Mr. Walshaw and set out in ID 10, are not artists' impressions as suggested by Councillor Foster. They are from accurate survey and use the scheme design to precisely show the visual effects of the basins over this very limited and very restricted area of view. They show the fallacy of Councillor Foster's suggestion that there would be dam walls. The scheme is subtle and natural. It does not block views up or down the existing small valley created by the spoil heap in the Greenbelt. Indeed, as Councillor Foster accepted, you can't tell from these photos that there's anything there, whilst he had no valid basis for criticising their accuracy. In terms of Greenbelt purposes, Mr. Rollinson was very clear that the key part of purpose 138A was to check unrestricted sprawl. The checking function is what the Greenbelt should do. This is not undermined by the appeal proposals. Indeed, the converse is true. The basins will be a permanent feature that can't be built on, at least for the life of the housing development. In terms of encroachment into countryside, the basins do not create any realistic encroachment and will prevent it in the future. So the Greenbelt's ability to continue to serve its role as checking sprawl and safeguarding the countryside from encroachment will not be undermined by these proposals. It will indeed be enhanced. And the ability to control the development and achieve a Greenbelt compatible scheme by the imposition of conditions does seem now in principle to be accepted by the council, and quite rightly so. Unfortunately, it hasn't been in the past. And so that's Mr. Rollinson and the appellant's Greenbelt case. I contrast it with the council's approach. Councillor Foster chose to give evidence on a complex policy topic, despite no policy expertise, having not dealt with any similar case, and certainly not as an appeal. This was so notwithstanding the council being represented by an external planning consultant. He was also a main mover in the original refusal and was clearly keen to try to fight the case on all original reasons for refusal, despite the fact that the council had legal advice to the contrary, including as to the risk of costs being awarded against it. Despite the illustrative additional materials submitted on the 3rd of February this year by the appellant, as agreed at the case management conference, in an attempt to give the council yet further clarity to the very modest nature of the effects of the Greenbelt, with the council indicating in its statement of common ground that it would consult on this material and seek advice of others, Councillor Foster, in spite of that, could not explain why this had not happened, why that consultation did not take place, and it appears that he alone has decided to press on with the argument. Although the reasons for refusal are clearly expressed as being about a lack of detail to make a judgment, and the assumption of inappropriateness as a result, that is clearly not now how the case is being run. There was never a request for more information from officers or the council prior to the refusal of permission. There is, however, now a reluctant acceptance that conditions could have addressed many of the items of development, structures and buildings, for example, that the council appeared at the point of a refusal to be concerned about, and by precluding them from being allowed in the Greenbelt. Surprisingly, though, all of these items still feature large in the councillor's evidence. Despite clear legal authority to the contrary, it appears that Councillor Foster's proof was drafted on the basis that very substantial weight had to be given to any Greenbelt harms in the context of determining whether the terms of paragraph NPPF 150 are met, preservation of openness and not conflicting with its purposes. Whilst that matter has clearly confused him in cross-examination, with acceptance of the error followed by denial, it's now conceded by Mr. Howlett in his cross-examination of Mr. Rollinson. However, the point doesn't rest there. It appears the council misdirected itself and approached the matter in the wrong way, which will inevitably have coloured the outcome of its judgment. At the time of refusal, at the time of reinstatement of the intention to fight reason 2 in December, and in the way it's put its case to this inquiry. To compound that particular misdirection, there is an even more fundamental one, the understanding of what preserve the openness of the Greenbelt means. To suggest, as Councillor Foster does, that preservation of openness requires an effect that is neutral, not at all negative, not even to the smallest degree, is a serious error of policy interpretation. Councillor Foster could not explain where he'd got that notion from and could point to no policy case or decision that supported it. It is not consistent with the framework or the local plan, and certainly is inconsistent with the views of the Supreme Court. It is also dramatically different to the approach in recent appeal decisions and in those local authority decisions that have been upheld as lawful by the courts. Not only is this an incorrect interpretation of policy, that has inevitably coloured the council's approach to this case, but the characterisation of the effect of the proposal on the Greenbelt has been dramatically overstated. That's typified by the claim that the effects on the Greenbelt would be considerable, and a misreading of the section drawings by Councillor Foster, leading him to form the view that there would be dam walls within the scheme. Councillor Foster's proof is also littered with suggestions of things being proposed in the Greenbelt that he knows full well are not shown on the plans and can be conditioned to be excluded. Councillor Foster's suggestion that the mere fact of a cut and fill exercise will increase the volume of material in the Greenbelt and so not preserve openness is, firstly, he accepts a guess. Secondly, in any event, takes no account of the fact that the site is, in fact, the whole site, the development site for housing, where cut material can be filled elsewhere. And in any event, misses the obvious point that a neutral cut and fill balance within the SUDS area of the Greenbelt, by definition, results in a neutral effect on openness anyway. In visual terms, it's clear that Councillor Foster's effective agreement with Mr. Rollinson that views of the part of the SUDS area in the Greenbelt will be localised. You're able to go further south than the spoil heap in order to see for yourself, even as far as Spink Hill on your site visit, but you won't be able to see the land on which the basins are proposed, let alone the part of that which is in the Greenbelt from those locations. In terms of Greenbelt purposes, it seems the zenith of the council's case is that SUDS must be urban because the name suggests this and because the use is related to residential development. This fails in a really fundamental way to ask how this scheme in this location undermines the Greenbelt's role in terms of the ability to check sprawl and safeguard the countryside for encroachment. Time and again, the councillor seems to suggest that the Greenbelt boundary was being moved instead of setting out how the proposal conflicted with Greenbelt performing its purposes. Councillor Foster's other examples of SUDS, he sets them out in his Appendix 2, don't advance any understanding of the effects of the appeal scheme. They are not remotely similar examples in location, type or design. In contrast, Mr. Rollinson's rebuttal at Appendix D for a scheme he was involved with, the last page of that appendix, provides a much more comparable scheme. Further, Councillor Foster's change of use argument is groundless. Firstly, it's based on a misunderstanding of SS10 as a policy. The word include could not be more obvious as a signpost of an open list. However, even if the councillor was correct, he would have identified the policy, that would have identified the policy inconsistent with NPPF and therefore out of date with reduced weight applying to it. If actual effects of the use of suds basins are in any event, if material is a change of use, clearly de minimis, the use should not be conflated with merely restating concerns about earth moving, which is all that Councillor Foster did in making that point in his proof. Finally, of course, there's Councillor Foster's point about the local plan process, and whilst this was put with much gusto in the council's opening and the councillor's evidence in chief, on analysis it was done so on a misunderstanding of the facts. Whilst the original representations of the local plan included a master plan that appeared to show the basins in the allocation, this was based on preliminary work in February 2018, developed into detailed work by the time of the application being lodged some 8 months later, as explained in Inquiry Document 9 and by Mr. Rollinson in chief. By October 2018, the application that forms this appeal was lodged, and this had the suds essentially as they are now. In the submissions to the examination of the local plan, Harworth responded to the inspector's questions about flooding and drainage by reference to the current application and its supporting information, referencing the application directly. This was subsequently relied upon by the inspector, as recorded in her report, stating that the site could accommodate, at that time, 393 dwellings based on the technical report submitted with the now appeal application. The most realistic interpretation of these facts is that the council and the inspector were fully aware of the intention to locate the suds basins in the Greenbelt and were not concerned that this needed a different allocation boundary, given the position experienced practitioners would take to such a matter and the common nature of suds in the Greenbelt elsewhere. Though a subtly different point, the comment from the local plan inspector at paragraph 182 about reinforcement of the southern hedgerow and careful green space planning is planning to assist in mitigating the visual effects of the housing development and creating a strong green belt boundary is consistent with these proposals as explained by Mr. Rollinson. Indeed, that is what the appeal scheme does. So then I turn to other matters, non-green belt matters, I suppose not the main issues by definition. And I'm going to take this slightly more quickly and largely as read. One matter that was underlying reason for refusal, one was conflict with policy LC1. There's an agreed position in the statement of common ground. The council's argument was run and lost at the Primrose Lane appeal inquiry. In that case, the inspector awarded costs against the council for running that argument, and I quote in the written submission what the inspector said on the point. Public transport. This was a reason for refusal. It should never have been. This is a recently allocated site in the adopted local plan. The suggestion that it is not located so as to have good enough access to local transport seeks to ignore the allocation. The whole point of the local plan process is to choose the best sites in all the circumstances. They may not be perfect. We have to live in a real world. That's what the local plan inspector did. And when she comments that there were some aspects not suboptimal, that cannot be construed as unacceptable. Otherwise, the allocation wouldn't have been confirmed. I set out for you, ma'am, for your note, where in the statement of common ground and the evidence you will find answers to all of those points. Traffic, much the same, but what Mr. Blair has done is that he has gone back to the county council to make sure that his position is understood and agreed by them as the highway authority, and it is. He has demonstrated that the actual level of traffic growth has been less than expected at the time of the original TA, that the future growth is now less than was predicted, that the actual traffic generation rates are lower, that traffic speeds are lower, and that there's been no material change in accidents recorded. And as a consequence of doing considerable work in relation to the capacity of junctions, links, and new accesses, he is quite content, as is the county council, that there will not be a problem. In relation to off-site junctions, and we did touch on this briefly yesterday, there is one junction where there is a question about the need for it to be improved. That is at Bridge Street and Sheffield Road. And so the approach agreed is that further assessment is to be taken before 200 homes are occupied to see if improvement is necessary. And if, and using the language of NPPF 110, it is necessary to cost effectively mitigate any significant impacts, a cost-effective mitigation scheme within the adopted highway and incorporating controlled pedestrian crossing facilities is to be submitted for approval and implemented.
Mr. Sager, is that the condition?
That is the condition.
Yeah.
I forget the number.
That's okay. That's enough for me to piece it together.
Yes, that is the condition. In terms of mining, great deal of information provided, Coal Authority fully engaged, Coal Authority fully satisfied. It's a situation that isn't unusual. Mr. Friel has considerable experience of similar situations, including situations where some recorded mine entries aren't found at the outline stage. The matter is conditioned, and the process of looking for and sometimes not finding them is overseen by the Coal Authority. Education, again, a high level of agreement. The issue really only relates to the need to provide a contribution for special education needs. The primary schools in Killamarsh have a massive amount of spare capacity, and the only issue is that St Giles, the closest school, has a more limited capacity, but still a surplus of 41 places. But the other school, Killamarsh Infants and Juniors, has a surplus of some 180 spaces, in combination far more than is needed to accommodate the development. And the difference between the two is that one is 500 metres further away. In terms of doctors and health, again, a fully resolved matter. The contribution has been calculated in line with a formula. The formula is endorsed by the Council's infrastructure delivery plan. The latest iteration of the calculation has one figure change, that's the build cost we discussed yesterday. And the way that that has been calculated is for all 397 dwellings. So as the consequence, the section 106 proceeds on the basis of each dwelling paying 1/397th of the total cost. Mr. Rollinson's healthcare statement does, however, demonstrate that across the relevant GP practices in the local area, there is capacity without improvements. So again, one could form the view that the situation is similar to the education issue for primary schools. Capacity overall, just not at the closest GP, similar to the St Giles point I mentioned a moment ago. In terms of public rights of way, of course, this is an outline application. The actual alignment of development and the treatment of footpaths is a matter for later, but the current illustrative master plan shows all paths retained without diversion. They are not retained on footways besides roads, but go through green corridors, save, of course, for where they cross roads, which is inevitable in order to accommodate the allocation. And Mr. Walshaw's statement identifies how the paths have been dealt with, treated, and provides considerable detail. He also responds to the position of local residents. Flood risk and drainage, again, a matter of statement of common ground. And I refer you to the statement of Mr. Parks and to ID 9 when he responded to some of the points raised by local residents on day one of the inquiry. Air quality, I refer you to the statement of common ground, the air quality assessment of Redmore, and the response to the local residents' criticisms of that in ID 7. Ecology, again, a matter all agreed. I refer you to Mr. Baker's statement and his ID 11, which responds fully to all the matters that have been raised by local residents. And I reiterate, the scheme will provide a net gain for hedgerows of 128.8% and a net gain otherwise of 6.93%. And this is achieved both on-site and off-site. And we looked at it yesterday. The fourth appendix to Mr. Baker's updated ecology report contains the plans of what and where is intended. Heritage, I mentioned briefly. The effect on listed buildings is not a matter of concern to local residents or the council, but of course there's a statutory duty to consider them. To address that, I direct you to the statement of common ground, to Mr. Rollinson's proof, and to the core documents, and I've listed them to give you some signposts as to where I think you need to look. Of course, you now have the listings of the relevant buildings, and we say there are essentially three located next to and include Westhorpe Farmhouse. They are separated from the site physically and visually, and they're on the other side of Westhorpe Road from it. Any effects on significance are agreed to be negligible and readily outweighed by the public benefits of bringing forward the allocation. So then we turn to the balance. The appellant doesn't seek to suggest there are very special circumstances because there is no need to. The proposal fully accords with the development plan and the framework. Section 38(6) of the plan, of the Act requires the determination to be made in accordance with the plan, and the NPPF requires that development is approved without delay. The appeal scheme accords with SS10 of the local plan and NPPF 150. However, there are a number of significant benefits, and although there are some matters that need consideration on the negative side of the equation, these are, as explained by Mr. Rollinson, essentially neutral. Pretty well, each of the benefits is acknowledged by the council. The difference is a matter of weight, and the council's position is that if there was another scheme to come forward that didn't include any greenbelt land, it would be approved, and so the benefits of this scheme are limited to the difference. But the council's approach, I say, is wrong for a series of reasons. There's only one application before you. There's only one planning application and only one appeal, and it's this one. That application has already taken 5 years to get to this point, and we still don't have planning permission on an allocated site. And the council has shown a clear propensity, supported by Rage, who clearly consider the allocation of the site in the plan as an error and can't come to terms with it, to refuse permission for all sorts of other reasons. Indeed, Councillor Foster in particular would happily have seen the appeal defended by the council for all 7 of the original reasons, even in the face of legal advice to the contrary. So, Ma'am, the whole notion of proceeding on the basis of marginal benefits doesn't stack up with the facts and the history here. Further, the housing needs are not a maximum, and land supply needs to continue to be provided for. Maintaining a 5-year land supply is an ongoing matter. Affordable housing needs exist here and now. The council's approach of saying we can't meet the full needs, and though there is a massive and increasing waiting list, little weight should be given to attempts to address it, is simply missing the point. There are substantial benefits from attempting to meet those needs now. Employment benefits also derive from the development and its related spin-off investment and spending. These benefits are fully consistent with the regeneration policies for Killamarsh in the local plan. The benefits of ecological gains are also significant, so too the school and drainage points raised by Heather Nola and Alex Parks in their evidence. The school point, Ma'am, is not about weight to the monetary contribution. It's making sure that in the case of the Killamarsh Infants and Junior School, which is so many surplus spaces, it actually has enough children in it to keep and maintain its viable future. In addition, new accessible public open space far above policy requirement is at least of modest weight. The appellant submits that whilst these matters do not amount to very special circumstances, they are nevertheless significant in the overall balance and are in favour of the appeal being allowed. And ma'am, for all of these reasons, the appellant respectfully asks that the appeal be allowed and that you grant planning permission. Thank you.
Okay, thank you very much. I think that's really the end of all the formal business in this inquiry. So that really just leaves me to say just really to thank everybody for your conduct during the inquiry. I've already mentioned this, but the interested parties, you organised themselves very well and behaved impeccably on what is clearly very important issues to them. So thank you for that, because it does make the running of an inquiry easier, and it actually makes it easier to understand your points of view. And just generally, thank you for everyone for your hard work this week, because I think it's been quite a fairly busy week, even though it's a relatively short inquiry. And thanks for your flexibility in moving online when we did overrun today. And particularly thanks to the council for being able to set that up at late notice. And generally the venue and this virtual forum have worked really well. So thank you for that. I think that's all I really have to say. So really that just leaves me now, unless there is anything anyone wanted to say finally.
Just that, I mean, the local residents probably won't want this from me, but I endorse what you just said. I think they did marshal their thoughts very precisely, clearly, and good for them. The fact that I don't agree with their position is a different matter. Yeah,
I absolutely agree, and I mention it because I've seen interested parties not behave in such an organised and well organised manner, and it really does help inquiries if they can do it. I appreciate, you know, that it's difficult for them, but they've done remarkably well in the circumstances, so thank you for acknowledging that. Okay, if there's nothing further then, I'm just going to say that the inquiry is closed now and a decision will follow in due course. So thank you.
Thank you.
Good afternoon.
Good afternoon.
Good afternoon.